Hey everybody, welcome to week 3. We're now halfway finished, just this week and next week to go. This week we have 2 topics, judicial resources and the unauthorized practice of law. So we'll talk about judicial resources. So we're moving on to a new branch of government. Last week was legislature, this week is judicial, next week will be executive, but this week it's judicial resources. And there's going to be a lot that you're introduced to this week. These include court structure, both federal and state. So for those of you that aren't familiar with the court system, hopefully you will be more familiar by the end of this week. There's trial level, and then there could be an appeal, and maybe there could be like another level of appeal. The adjective for that is appellate. That word will show up a lot. So there's an appeal to a trial court decision. There can be an appeal to an appellate level decision. So I just want to make sure you understand what those words mean. Part of that also means jurisdiction, and there are some slides on this. Jurisdiction is a big legal word that pops up a lot, but it's important in helping you assist patrons. At the end of week 2, in the research assignment, you were asked to analyze a fact pattern and talk about the where. Where is important for jurisdiction, but where is also important as far as understanding personal jurisdiction, whether a court actually has power over a person or whether a court has power over a subject matter. And there are examples in the slide just so that you understand that jurisdiction is a concept, but it's also important when we come to mandatory and persuasive authority. So another example that we've given, and I use Nevada because I live in Nevada and I work for the Nevada Supreme Court. The Nevada Supreme Court is the highest court in the state of Nevada, the court of last resort for state level issues, absent constitutionality things of U.S. constitutional things that could then ultimately go to the U.S. Supreme Court. But if the Nevada Supreme Court hands down a decision, every lower court in Nevada, the Nevada Court of Appeals, district courts, they're bound by whatever the Nevada Supreme Court said on the law in that particular case. Over time, this body of law, there is standing precedent. Later courts have to be cognizant of and abide by earlier case law so that there is predictability and outcomes. People can research the law and say, well, in all of these other situations, courts applied the law this way and this was the outcome. That's what we call stare decisis, and is one of the most important things in a common law jurisdiction, meaning the United States, as opposed to civil law, but that gets us into foreign law, which we're not talking about in this class. So Nevada has all of this law that all lower courts must abide by. Utah, right next door to us, does not. Utah does not have to look at our case law and be bound by it. They can look at it if there's nothing in Utah case law. It's a matter of first impression. And they might look next door to Nevada and say, well, Nevada has a case on this. And, we really like the reasoning that the Nevada Supreme Court put into writing this decision. So we think, that's a good rule. And therefore they put forward that rule. Now Utah has a rule. And all lower Utah courts are now bound by that Utah Supreme Court opinion. Utah now has binding precedent on that legal issue in the state. It doesn't need to look outside its borders anymore. But states do that all the time. New legal issues come up because the world changes, and no matter how well legislatures think they write a statute, there are all of these unforeseen things that pop up or unforeseen ways of interpreting a statute. And then a court has to look at this new law and they have to interpret it. And if it never existed before, it's a matter of first impression. Maybe a sister jurisdiction, though, has looked at it and they have analyzed it. So that's the difference between mandatory and persuasive, and that will come up today as well. Obviously, just like last week, in learning about statutes, we're going to learn how cases are published. So there's the way that they're published in print and what that looks like online. So there is a slip opinion. Compare that to a slip law. The first version of a statute that comes out, the first version of a case that comes out is called a slip law. In the print world, there's one more step, and these are things called advance sheets. They're paperback supplements that accompany print reporters. And then once you have enough of these paperback supplements on the shelf, they get replaced by a hardbound reporter. That's a general rule for how case law publication works in print. Advance sheets don't make any sense online. Whenever a court issues an opinion, there's the slip opinion, and then eventually online it gets placed into a reporter. With the reporter citation, advance sheets just don't make any sense in the online environment. We'll talk about citations. You should be able to understand what a case citation looks like and be able to pick it apart into all of its component parts and say, well, that's a volume number, that's a reporter, that's the page number on which the case starts, that's the court information in the parentheses so that I know which court it came from, and the year, that's the year this case was decided. Lots of examples in the slides. I think that's a core fundamental legal information literacy thing to get out of this class, is recognizing a statutory citation when you see it, recognizing a case law citation when you see it, and how to pick it apart. We're also going to research cases, and that's another core skill that I want you to get out of this class, much like finding a statute. In week 2, we saw that there were lots of ways to find statutes: by a known citation, using an index, keyword searching, a popular name table. Case law has their own set of search strategies. There's always full text searching, and we'll see that, but we'll be doing it in Google Scholar, and we'll be doing it in Google Scholar and state judiciary websites because they're free. Lawyers use really expensive tools like Lexis and Westlaw, and those services are also accompanied by a lot of really sophisticated tools to help attorneys expand their case law research with just a few clicks of the mouse. We're not in that world, but that's okay. Based on what most of us are going to have to do when it comes to case law research, is never going to be anything that sophisticated. So you're going to be asked more often than not by someone who comes in, I would like cases about a bus crash when the driver was sleepy. Okay. Now, it's possible across the United States, there are cases that were about drowsy school bus drivers, and presumably there's an accident. That's why you want the case. Someone was liable for negligence, or maybe not, but negligence would be the theory of the case. Someone fell asleep, they had a duty to be awake, people got injured, right? Okay, so the first step in any litigation is there would be a trial. Most litigation is at the state level. Many things settle before they ever go to trial. But let's say we go to trial. Most trials, especially if there are jury trials, are questions of fact. Was someone negligent? Okay. Maybe there is a decision and there's finality. Then there might be an appeal. There might not. The person who lost may not appeal. But if they do, then there's an appellate level court. Appellate level courts don't care about facts. They care about the law. Appellate courts are going to look back at trial level courts and say, did the trial court get the law wrong? Appeals are not where we relitigate facts. Parties don't get to have another bite at the apple to prove negligence or disprove negligence. The court at the appeals level says it was an error for the judge to allow certain evidence in, and therefore it got to this particular outcome. And an appellate court can say, because of that legal error, there can be a new trial. At that point, there's another bite at the apple to get what was wrong, not wrong the second time. Because the application of law is more important, that's why appellate level opinions are what you are going to find in research. So let's go back to our patron who comes in and wants to find cases about a drowsy school bus driver. In reality, you're probably not going to find that many in your jurisdiction, but what you are going to find are cases in your jurisdiction that talk about negligence and when someone is or isn't, whenever certain situations exist, like drowsiness or insufficient training or any number of things. So your patron is looking for something very factually specific that likely may not exist, but there could be all of these other cases out there that have the same legal issue, negligence, even though it's not in a school bus setting. And that's what lawyers do, because we're never going to find that case that is 100% on the facts, in the jurisdiction, the outcome we want, everything. When I taught legal research to law students, we always called that the spotted cow case. It's 99.99% never going to exist. Like the cow with all of the same number of spots, size of spots, color of spots, distribution of spots, all over. Law is finding those cases that have a legal rule that you then apply to your facts. So this is a long-winded way of saying patrons tend to get disappointed when you explain to them, I can show you how to do a full text search on Westlaw or Lexis if your library happens to offer public access to those databases. But here's why you're not going to find it. And it's an opportunity to have a civics education moment to say, an appellate court isn't going to necessarily hear this, especially if it doesn't break new ground, which gets us to another point about not every case that's published at the appellate level, not every case that is finalized at an appellate level results in what's known as a published or reported opinion, meaning an opinion that will end up in a reporter, the actual book. Otherwise, there has to be a written resolution to a case or an order. But if it doesn't break new ground, if it's like another plain Jane vanilla negligence case, there's nothing interesting there. There's no new interpretation of the law. There's no new distinguishing of prior precedent. Courts have to write something down and give a final resolution, but they deem it unpublished. And unpublished cases in almost every jurisdiction do not have precedential value. There are rules that restrict when and how you can cite those cases to the court. Sometimes it's never, not always, but sometimes it's never. So we'll talk about the distinction between published and unpublished cases in here as well. We will talk about dockets. Dockets are nothing but like a list of all of the documents that are included in a litigation. So trial level, things that you'll see, you might find the complaint, which is the initiating document of a lawsuit. If I sue you for negligence, the first thing is I have to write a complaint and I have to serve it on you. Then you have so many days to write an answer. That's what it's called, an answer. And that's another document in the litigation process. And then you would see that on the docket. And so on and so on and so on. For every single motion, pleading, everything that's possible in that litigation shows up on that list. And the slides go into a little detail why you might sometimes need to research in dockets. I give you one question on your research assignment this week on researching dockets just so that you see them. The other thing that we're going to talk about are court rules. The courts get to write the rules about how things happen in their courts, as well they should. These are procedural rules. We talked about these in week 1. It's how to do things. So for example, court rules will tell you what margins should be on filings that you file with the court, if they have preferred fonts, if they have specific deadlines by which you must submit certain documents. This is a lot of how the court works. This isn't contracts, this isn't criminal, this isn't bankruptcy, although bankruptcy was a bad example. There can be bankruptcy court rules. So we will get a chance to look at some of those as well. One thing that I want to talk to you about, even though there's not really a way of researching it, is these things called a citator. Your spell check is going to want to call it citatory with a Y unless you change it, and I've always been too lazy to change it. What citators do, they're citation tools. So what can happen is you have a case in hand. You can type in its citation into Westlaw or Lexis, and it pulls up the case, and then there will be a button that you click. And that button shows you every case that has occurred after your case in hand that has cited your case. So as we all know, the law changes. So there is a possibility that in one of those later citing cases, they say something like, your case in hand, the one you're citating, is no longer good law. That's one of the obligations that attorneys have when they do case law research, is they have to make sure if they are going to rely on this case in hand for an important legal point in the documents they're submitting to the court, that it's actually a statement of what the law actually is in effect right now. Because if you submit something that isn't good law anymore to the court, two things are going to happen. Opposing counsel, who has done their due diligence and they have cited everything, is going to be like, yeah, that's not the law in this jurisdiction anymore. So you look like an idiot. And when you look like an idiot screwing something up that most first-year law students learn how to do, that's grounds for malpractice. I point this out because this is an important step for some of you, depending on where you work, the type of assistance that you'll provide. This is what we call updating. And this is subsequent history, things that happen later down the line in time that could impact the good case that you found. So it's a responsibility in the legal research process to update the research that you found. So that's a lot for judicial resources. I think the slides are pretty thorough this week. I encourage you to read them, and as you're reading them, if there is a concept that you don't understand, please ask in the forum. I can go into more detail. Obviously, I have no problem talking about this stuff. These videos are getting longer than I ever intended them to be. Or if you want to email me directly for clarification on things, I'm happy to field those questions. So the second thing we're going to talk about, and I've mentioned this a few times, is the unauthorized practice of law. This big scary thing that looms out there, that if you go too far in what you're doing, you're going to go to jail. So two things: every state does have an unauthorized practice of law statute. And now that you know how to research statutes, if you are so inclined, you can go find your state's unauthorized practice of law statute. And then there is also usually some case law published by the state's highest court that elaborates on what practice means in the practice of law. And usually what it means is you're applying law to facts. So let's think back to last week when we talked about the legal research process. One of the last things that you do after you found all of the relevant legal information is to read it and analyze it, figure out what it means. And if you find a bunch of cases, you synthesize them so that you can conceive of what the general rule on this legal issue is. We said that's generally where library staff need to stop, unless you work in a firm and you're assisting an attorney and you are requested to do some rudimentary analysis of the research that you found. If you work in a court and you are asked by a judge or a justice or a staff attorney to do something, that's fine. They're still attorneys. They're still going to make their own call and their own decision and choose what to use. But if you're working with the public, you absolutely need not be analyzing facts, applying the law to people's facts. And by facts, I mean the story. Sometimes the heart-wrenching stories that people come into your library and they tell you about. And because you work in libraries, you want to help them. You really do. But you have to understand where the line is, because you're not an attorney. So the slides and videos this week are going to go into more detail, give you some examples of what this looks like at the reference desk and how you can avoid it. But here's the rule of thumb, and this is what I have been able to internalize as far as this is concerned. The moment a patron asks you a question and it includes the word should I sue this person? Should I file in this particular court? Should I fill out the form this way? You should never answer a question that includes the word should, because should is begging for advice. They're wanting you to tell them what to do, and of course they are. The legal system is scary and it's messy, and They're trying to represent themselves and they don't have a legal background and they are coming to you for help and you want to help, but you cannot. You need to understand where the line is. Now, the good news is that no librarian or library staff member has ever been charged with an authorized practice of law. I include this because it's something you should be aware of, not something you should be scared of. It's just part of figuring out what your line of service is going to be to your patrons. So that's it. That's the overview for this week. As always, there is a quiz. Again, I highly encourage you to take it as soon as you watch the videos and read the slides while it's fresh in your mind. There is a research assignment. As some of you might be able to see from the first time around, I'm pretty picky in how I grade, but that's why there are resubmits if you want to have another bite at the apple. And another discussion question, and it's about PACER. Some of you might know about PACER, some of you don't. It stands for Public Access to Court Electronic Records. It's a big deal in law librarian world. And there is a discussion question about that. So remember, always feel comfortable to ask questions in the forum, email me directly, and yeah, that's it. So welcome to week 3.